Now, this is how trusts progress. Unlike a will, which is, more or less you die and that's when everything starts happening, a trust can live for years. It can live for generations. There's first the aspect of creating and executing the trust. There's then funding the trust, naming and changing account titleships to the name of the trust, or beneficiaries being named as the trust, because the trust then names the beneficiaries of those funds. Then the initial beneficiaries, if it's a revocable trust, it's me, and when I die, it might be my wife or my kids, or it may be the Hump Water Buffalo charity, whoever it may be. Then those future beneficiaries at some point will cease. Something will eventually be distributed that ends this trust, and that will lead to the final distribution and dissolution of that trust. Now, creating and executing the trust. Interesting points to bring up. It does not need to be executed by the settlor and the trustee at the same time. It can be, it should be pretty close to the same amount of time, but it doesn't need to be at the same minute. It could be different days, it could be different weeks, but it doesn't have to be at the same time. Number two, it does not need to be witnessed. This is a contract that, unlike a will, does not necessarily require 2 witnesses. Wills require witnesses, sometimes 3, depends on your state. Now, not all wills do, but I'm not getting into that. Nuncupative wills, etc., which are valid in a handful of states, they're not. Okay. Now, the trust does need to be notarized by the settlor and the trustee. We need to know that the person who signed is actually the person that signed. So that's a requirement that needs to happen. Now, it does require to have a greater mental capacity than executing a will. So a trust can't just be created and executed by someone who's off in the bushes. A power of attorney may have the ability to execute a trust for certain people, by the way. And again, I would ask you to go through your state's power of attorney form to do that, but that may be your big way out in certain circumstances. Now, funding the trust, we will spend more time going over this in the future, but here's the simple part. Current assets, meaning things that I can change the ownership to now, that's what I want to change now, clearly, or in the near future. So my bank account that I can freely exchange anytime I want, that I'll distribute and name to the trust now. Deed changes. I own the real estate now. Now, if there's a mortgage, technically, like the bank can say, hey, we're calling this in because, you couldn't do that. But again, I don't want to get into those things right now. My experience has been that most banks, as long as they're getting paid, they tend not to do that. But again, I want you to read the mortgage before you just transfer a deed that has a mortgage still attached to it. But if it's paid off free and clear, there's no mortgage whatsoever, you can name the trust as the owner to that deed of the property. And again, LLCs and corporations are absolutely essential to have the trust as owner. Now, this is how you do it for an LLC. You will have a 1.5-page assignment that just says, I, Daniel Timins, am leaving fill in the blank, my LLC, real estate LLC, to the trustee of the Daniel Timins Revocable Trust, who also happens to be me and someone else in the future. And I will have that signature on that assignment notarized. I have now effectively, in most states, assigned that interest in my LLC to my trust. So when I die, we don't have to wait for probate. The same thing with S corporation stocks. Now, before you go and do that with S corporations, remember S corporations have certain limitations as to who can be owners. You will need a specific provision in your trust stating that the trust can be the owner of S corporation stock because it's technically owned by an actual individual who can be identified. And again, would need to follow all the same requirements that would normally be required of an S corporation stock regarding their membership. And then there are future assets. Future assets are things like life insurance. And you say, well, I have a life insurance policy now. Isn't that an asset? And the answer is, kind of. But it really pays out in the future. Bad news, when you die, you don't even get the benefit of it. But your family does, so that's good. There you're going to name a beneficiary, and we'll talk about that later. And the same thing with retirement plans. With retirement plans, the important point is I can have the retirement plan in my name while I'm alive. I can't transfer that retirement plan to someone else except my spouse if we get a divorce without having to take money out of it. So that's technically a future asset because in order to transfer it, I have to either die or I have to take money out of it, which means it's no longer a retirement plan if I take money out of it. And then there's the initial beneficiaries. It depends on trust to trust. A revocable trust that I create for my lifetime, I'm going to be the initial beneficiary. For irrevocable trusts, it's typically going to be somebody else. as the initial beneficiary. And here I talk about things like a charitable leads trust. The charity is the initial beneficiary because it is a charitable leads trust. If it's a charitable remainder trust, it's my human beneficiary because the charity is the remainder person. Grantor retained annuity trusts, things where I am the creator of the trust. I retain the trust. So when you see acronyms like CLUT or ILIT, I want you to stop and I want you to think of what that acronym is saying. ILITs, Irrevocable Life Insurance Trust. It's a trust dealing with insurance that's based off of my life, and the trust is irrevocable. You can do it both ways. But that's the point. I want you to look at that acronym. Now, future beneficiaries in the meantime are people that take over after the initial beneficiary, quote unquote, has passed away or is pushing daisies. My point is that for someone like me, if I create a revocable trust for my lifetime, it then goes to my descendants or my spouse. An irrevocable trust will go to the remainder beneficiaries. And then there's the ultimate distribution and dissolution. When you're working with a client who has a trust and they're saying, I want to dissolve this trust for whatever reason, the beneficiaries are the right age, etc., there are a few things that are going to take place. There's going to have to be a final accounting. You have to give a final accounting to the beneficiaries. All right? It doesn't necessarily need to be a judicial accounting, meaning that it's put into the court's paperwork, which is a pain in the neck. But hey, it's great billable hours. The clients tend not to like it, and it tends to be, like I said, a pain in the neck. That's why you're getting paid for it. Hopefully. You're never going to get paid enough for judicial countings, by the way. Last but not least, a final release should be signed by the beneficiary saying that I've gotten everything. Why is that? Pretty clear. You represent the trustee a lot of the time. You have to make sure that the trustee is released of their obligations. They should have a final release that's signed by the beneficiary who says, I got all the money and I'm not going to bring a lawsuit in the future.